Hello, welcome to our webinar. Thank you very much for joining us on Harpur Trust and Brazel and how to navigate the part-time employee holiday windfall. For those of you who don't know much about Burkitt's, this slide is designed to just give you a little crib shot of Burkitt's, our size and breadth of and range of legal services. But what we'll be covering today, we'll be looking at the holiday pay update, but to begin with, in order to explain how we have got to the situation that we're now in with Harpur Trust versus Brazel, we'll be taking you through the legislative and case law build-up to try and explain a bit of the background as to the decision that was reached in that case. We'll then be looking particularly at Harpur Trust and the pertinent facts and the implications of that case. And then we'll be looking at what the options are to you, and then we'll be responding to your questions. We have had quite a range of questions in advance. We will be looking at those. If we have time, we will also look at the questions that you're invited to put in the chat function, but due to the numbers of people we have today and also the amount to get through, we might not have time to look at many of your questions, but we'll do the best we can. In respect of technical issues, if you have any technical issues whilst we go through the webinar, if you just put something in the chat function, our support team behind the scenes will try and help you as much as they can. So your speakers today, we're both on screen now, hopefully. So there's me, Abigail Trencher. I'm a partner in the employment team of Burkitt's. I'm based in our Cambridge office, and I'm joined today by Sonya O'Reilly, a partner who's primarily based in our Ipswich team. For those of you that would like to get up-to-the-minute updates and news on employment law and lots more, then you are invited to download our app, which is available on the Apple Play Store and Google and Play Store and Apple Store, using those QR codes. But if you look us up, Burkitt's app, then you can download it to your mobile phone. We are running our annual updates. They're going to be run in October, and November at various locations, our 4 offices. And if you would like more information, that will be coming out in the communications that will be following our webinar. And alternatively, you can put that in the chat function, and one of our support team will ensure that we provide more information to you. We'll be looking at all of the recent and forthcoming employment and immigration law developments. So it's of great relevance to anyone in HR practitioners or those with responsibilities for HR that want to know that they're up to date with all recent issues. So let's get started. So I'm going to hand over to Sonya now, who's going to take you through the legislative background to the current case that we've been looking at.
Thank you, Abigail, and yes, welcome. I'm really pleased to be able to share some thoughts with you today. We're really in a muddle, aren't we, with holiday pay? We're going to take you through, therefore, a little bit of the background first before we dig straight into the most recent decision that has caused you all to sign up for today's webinar. Because actually, I think it's really important to take a step back and to see why we've arrived at where we're at now in the holiday pay situation that we're in. So let's have a little look as we go through. I'm going to start off by taking you through a legislative update. So this is to take you through the law as it stands with the various legislative provisions. In 1993 then, we're going all the way back to 1993, and this was the point at which a European health and safety measure was brought into place, and that was the Working Time Directive. As well as dealing with hours of work and rest periods, it deals with holiday. And under that directive, all workers became entitled to at least 4 weeks of paid annual leave. And then it became a situation where the member states of the EU would then have to go ahead and implement that directive into their own national provisions. I think it's interesting to note at this point that the health and safety measure that brought the directive in really gives you a clue as to how the European Court of Justice views and interprets the Working Time Directive. It's all about health and safety, so time off to rest. And I think that really gives an indication as to how lots of cases have been decided over the years. And then moving on, in 1998, we come on to the next provision that came into effect. And this was the working time regulations that implemented the directive into UK legislation. So before this time, actually, in the UK, we had very, very limited statutory entitlements to holidays. They were limited to agricultural wages legislation and whatever was set out in somebody's contract of employment, or indeed collectively agreed provisions. But some 24 years ago then, we had the working time regulations that were brought in under the European Communities Act of 1972. And these are the main provisions that are set out in those regulations with regards to holiday particularly. So Regulation 13 set out that 4 weeks of paid leave would be given to employees and workers, and that Regulation 14 said that that leave would accrue at the rate of 1/12 per month in that first year of working. Regulation 14 set out the right to either be paid in lieu of leave or to have the leave pay deducted from somebody that was either untaken leave or overpaid leave upon termination of employment. And that's the only time that somebody would be entitled to any pay in lieu of untaken holiday. Regulation 16 then set out how people would be paid for that holiday, and it referred to sections 221 to 224 of the Employment Rights Act, which determines the amount of a week's pay. And it's that element that has, of course, caused such a huge complication over the years. And then we move on to 2007. And we've had a change in 2007, so the Working Time Amendment Regulations brought in the additional 1.6 weeks of leave, which means that workers now have 5.6 weeks of paid leave from the 1st of April 2009. And this was to ensure harmony, really, so that people got 4 weeks of holiday plus bank holidays effectively. And then moving on to 2014. The deduction from wages limitation regulations were passed into law. And this was in response to the Employment Appeal Tribunal's decision in Bear, Scotland against Fulton. And that's a case which Abigail will take you through in a moment. But it resulted in the government deciding that it was going to be important to support employers by limiting the potential for claims of unlawful deduction from wages going back beyond 2 years. So that the limit on those deductions was put at 2 years under these particular regulations. And then in 2020, the snappily titled Employment Rights, Employment Particulars and Paid Annual Leave Amendment Regulations increased the reference period for calculating statutory holiday pay from 12 weeks up to 52 weeks. Or if someone had worked fewer weeks than 52, then the reference period is the period of time that somebody has actually worked up to the calculation date. And there's also a slight added complexity whereby if people are not working for particular weeks across the course of that year, then you class those as non-counting weeks and you go up to a long stop date of 104 weeks, so 2 years, in order to identify the pay that should be calculated. And now I'm going to pass to Abigail, and she's going to take you through some of the cases that have been determined in this holiday pay area.
Thank you. Thank you. So now I'm going to look at the case law developments, because of course, wherever you have legislation, the courts can always be on hand and trusted to interpret any queries that are brought before them to interpret how that legislation should be deemed to take effect. Now, the first one I'm going to take you to is a European Court of Justice case, and it's Williams versus British Airways PLC. Now, this related to the aviation sector and specifically how holiday pay should be paid to those in the aviation sector, and here it was pilots. And when the European Court of Justice was asked to determine what paid holiday meant under the Working Time Directive, they were clear that it meant normal remuneration which was intrinsically linked to performance of tasks that the worker is contractually obliged to do. So that included the pilot's flying pay supplements. And that term intrinsically linked has been passed down and used by courts in subsequent cases. So the next case is the European Court of Justice again, when they were looking in the case of Robinson Still versus PD Retail Services and others in respect of holiday pay. And we've referred to this today because actually we received questions from quite a few of you on rolled up holiday pay. So this is the source of the issue. And in Robinson Still, the employer had been rolling up their holiday pay. So rather than paying holiday when the employees took it, instead it was rolled up as part of their hourly pay, their normal pay. And here the European Court of Justice was clear that holiday pay should be paid for the specific period of leave taken. It's a health and safety measure, remember. So what they were concerned with was the incentivization of employers to take the holiday, and they felt that they were less likely to be inclined to do so if they were not paid specifically for the period at which they're on leave. However, helpfully, the European Court of Justice did say that any sums already paid could be set off. So any rolled up holiday pay could be offset from the employee's entitlement to paid annual leave, provided the arrangement was sufficiently transparent and clear, and it was understood to be in addition to the pay for work performed. So moving on, we have the case of European Court of Justice again, looking at Locke versus British Gas Trading Limited. And this concerned the question of whether Mr. Locke's commission, which he earned on sales that he would secure in the course of his normal working hours, should be incorporated with his holiday pay. And it was deemed by the European Court of Justice that yes, it should, because it requires normal remuneration to be paid during for the holiday pay, and in this case, his commission was intrinsically linked to the performance of the task that he was contractually obliged to do. Now we move on to the it's the Employment Appeals Tribunal. So our national court, the Employment Appeals Tribunal, EAT, when they looked at the case of overtime and travel related allowances in the case of Bear Scotland versus Fulton. So the question there, similar to Locke with commission, was whether overtime and travel related allowances should also be incorporated within holiday pay. And the EAT determined that yes, it should if it's normally received. So the question then is whether on the facts of each case, whether the overtime or allowance is normally paid, as in there needs to be a settled pattern, an intrinsic or direct link, using that terminology from Williams, to the work that worker is performed to do. And that's why there's a question in respect of purely voluntary overtime, but now it's settled that any guaranteed overtime or contractually obliged overtime is likely to have to be paid within holiday pay because it would be normally received. And in that case, the working time regulations needs to be interpreted accordingly. And that's where the EAT held that it was very difficult to interpret sections 221 and 221 that deal with a week's pay in the Employment Rights Act 1996, so that it accords with the Working Time Directive, and therefore the working time regulation needs to be amended accordingly to ensure that normally received pay is included in holiday pay. So their determination is where you have pay that varies with the amount of overtime, for example, that is worked, then you would determine a week's pay looking at the average pay over the 52-week reference period. Now, helpfully, in the EAT judgment, It looked at a series of deductions of wages, and what was required for there to be a series of deductions when looking at unpaid holiday pay. And in their judgment, the EAT concluded that because an unlawful deduction of wages claim must be brought within 3 months of the date of the last deduction, it would follow that there shouldn't be an interval in a series of deductions of more than 3 months. So that would mean that you looked back over the series of deductions, and if there was an interval between deductions of more than 3 months, the individual wouldn't be able to claim for the deductions beyond that interval. And that was the position of the EAT decision in 2015. We then have the European Court of Justice decision in King versus Sash Windows Workshop Limited in 2016, and that related to a worker who wasn't deemed to be entitled to holiday by his employer because it considered that the holiday entitlement didn't apply to him, and therefore he was not entitled to paid holiday. And it was decided in that case that because there was no entitlement to holiday given to him, there was no limit on the amount of carryover, i.e. on the termination of his employment, he would be entitled to claim for all of the holiday that he had not been paid, because in order for a worker to take their right to paid holiday, they must know in advance that they will be paid for it. And following that case, we have the more recent one of the Court of Appeal's decision in Smith versus Pimlico Plumbers Limited in 2022. And that was very clear that unpaid leave taken by an employee where the employer refuses to grant paid leave should not be counted. And essentially, the employee is entitled to claim full leave entitlement without limitation. And that right crystallises on the termination of employment. So if you have an employee, a worker, such as Mr. Smith, who's not been entitled to any paid leave, has not been told that they can take paid leave during their employment, the length of their engagement with the employer, they will be entitled to claim all of the holiday they've not been able to take upon termination. And because it's not deemed to be an unlawful deduction of wages claim, because they simply haven't been given the right at all, there is no 2-year backstop, so there's no 2-year limit. Now, in this case, whilst a Court of Appeal wasn't required to specifically look at the Bear Scotland decision on a series of deductions, and in particular whether an interval of more than 3 months in a series would prevent someone from claiming deductions of wages for all of that series. The Court of Appeal did look at it in their obiter comments. They commented it in obiter, which means it's not necessarily binding, but it's got a lot of influence and likely to influence any subsequent case judgments. And the Court of Appeal cast doubt over the EAT's judgment and whether or not an interval of more than 3 months would stop and break a series of deductions. Their view was that there was little requirement and necessity to build that 3-month interval into a series of deductions. So we're now left after Smith and Pimlico with some uncertainty as to how good law it is that if you have an interval of more than 3 months in a series of deductions, that will necessarily break that series. So that's where we are before we come to Harpur and Brazel. I'm going to hand over now to Sonya, who will look at that case in particular.
I do hope you're following the ins and outs of all of the holiday pay shenanigans that have gone on over the years so far. It is complicated. And then we have Harpur and Brazel. So if we can move on, we're going to start now to actually look at those pertinent facts of this case. This was a case that was actually heard in November of last year, so 2021, but the Supreme Court actually then promulgated or announced its decision, its judgment on the 20th of July this year. So what are the facts of this particular case that has caused such concern? Well, this was a case where we had a lady, Mrs. Brazel, who was a visiting music teacher at the Harpur Trust School, a school run by that particular trust. She'd actually worked at that school for quite some time, since 2002. And she was indeed employed, in this case, on a permanent contract of employment. This is important, and it's going to become particularly relevant as Abigail and I talk through the various permutations and the implications of this decision. She was a permanent employee. She wasn't casual in that she was employed only lesson by lesson or term by term. She was under a permanent contract, but it had no fixed minimum hours. So that could be classed as a 0 hours contract. She was paid only for work that she carried out, no obligation to work, and no fixed minimum hours of work that she had to do either. She usually taught between 10 to 15 hours per week during term time, and those terms, given that she was in a school setting, were between 32 and 35 weeks per year, depending on the way the terms fell. And in this particular case then, the Court of Appeal, so prior to coming to the Supreme Court, the Court of Appeal had referred to Mrs. Brazel's working conditions as being a part-year worker. So that's somebody who was also part-time effectively. So she didn't work a full week, so she was part-time, and for large parts of the year, she didn't work at all. And that's what this case is all about. It's the nature of her part-year position that's particularly relevant, not just the part-time element of it. So moving on then to the next part of the facts, really. In her particular case, she was paid £29.50 per hour for her work. She submitted monthly timesheets and was paid in arrears for the hours she worked in a particular month. So her hours and her pay would change every month, depending on what she was actually called upon to do. Under her contract and, of course, under statute, the working time regulation, she was entitled to 5.6 weeks of holiday, and it was expressed to her that that holiday had to be taken during school holidays. So the way that the Harpur Trust originally worked out her holiday entitlement was to divide that 5.6 weeks of entitlement across the 3 school terms. So they divided 5.6 weeks by 3, which gave a figure of 1.867 weeks, and that holiday pay was then paid in April, August and December, so at the end of the Easter, summer and Christmas terms. And her pay was then calculated based on her average over the preceding 12 weeks, as the law was at the time, remember, the reference period used to be 12 weeks, in which she'd worked. Then, thinking that they were doing absolutely the right thing, the Harpur Trust read the then ACAS guidance to do with atypical workers. And it changed how it calculated her pay and how they paid her holiday pay. They used the calculation method of looking at a percentage, a 12.07% calculation of the hours that she had worked, and paid her pay on that basis. As I say, entirely following the then ACAS code of practice. But for Mrs. Brazel, this resulted in a reduction to the holiday pay that she was receiving. So if we move on, I'm going to explain how those various calculations were carried out. So this 12.07% figure might be something that you are familiar with, and indeed it is still potentially available as something that can be used, which we will talk about later on. But in relation to part-year employees, this is the part that's been called into question. So the basis of working out this 12.07% calculation is this. You start with 52 weeks of the year. You take off the 5.6 weeks of the working time regulations holiday entitlement, which gives you 46.4 weeks that are left to work during the course of a year. That 5.6 weeks is then divided by the weeks that are available to work and multiplied by 100, and that gives the percentage of 12.07%. So in the example of Mrs. Brazel, if she worked 127 hours over the spring term, multiply that by her hourly rate of 29.5 pounds per hour, that gave a figure of £3,600 £746.50. Applying that percentage figure, she was then paid, according to that percentage method, £452.20 for her holiday that she'd accrued and over that one term. That's the percentage method of calculation. That's the aspect that she then complained about when they moved to calculating in that way, because it resulted in a reduction for her. She asserted that she was entitled to holiday pay that was based on actual 5.6 worked at her average rate of pay. So if we run that calculation through, just so that you can see how that works, if she had worked 127 hours in a term, in this particular term that was the reference period for her that she was referring to, it was the spring term, and it actually only resulted in 10 weeks of work. So in order to get to the 12-week reference period, that was the relevant period of time at the time this case was initially decided, they added in 2 weeks from the autumn term as well in order to get to 12 weeks of a reference period. She worked 22.5 hours in the last 2 weeks of the autumn term, so in total 127 hours in the spring term, and those 22.5 hours in 2 weeks of the autumn term resulted in her working 149.5 hours. Multiplied by her hourly rate, that gave a particular figure of £4,410.25. Dividing that by 12 months of the year, that resulted in a figure of £367.52 per month, multiplied by her entitlement to holiday for that particular term, which, if you recall, was 5.6 divided by the 3 terms, which is 1.867. Her holiday pay using that calendar method, based on a full year, was £686.16. So a couple of £100 in the difference for one term. And that was the calendar method. I hope you're still with me. Let's move on then to the next part of the decision. So the Supreme Court then had to decide which method of calculation is the right method to use based on the working time regulations as we have them. The Supreme Court said that Mrs. Brazel was what they deemed to be a part-year worker, only employed to work part of the year, albeit employed on a permanent contract for the full year. And that's really important because this case is only about part-year workers employed on a permanent contract across the whole year. They went on to decide that all workers, as set out in the working time regulations, are entitled to the full 5.6 weeks of holiday per year, and that's a day one right. So it doesn't accrue over time, it is a right to that 5.6 weeks right at the start of any holiday year, apart from in the first year of service, where of course if somebody is only started working partway through a year, then it would be prorated at that point, or indeed on termination. But during normal years, the entitlement is a right to 5.6 weeks. Her pay varied then according to the hours that she worked. So the Supreme Court said that it was necessary to calculate her average pay over the preceding 12 weeks. Now that would be over the preceding 52 weeks, as we've had the change in the legal position on the reference period. And importantly, what the Supreme Court said was that you must ignore any weeks in which the employee or the worker here did not receive any remuneration at all, in order to then ascertain what the average pay would be across that reference period. And they said that therefore that calendar method of calculation was the correct way to address it. So in summing up then the Harpur-Brazel decision as we move on, the Supreme Court has accepted and made it clear that they accept that this has the potential to result in a windfall payment to part-year workers. They said that it's because no prorating of leave entitlement is necessary despite not working all the year, and because you only count those weeks where somebody is actually working and when they would have been paid, and you discount from that calculation any weeks where the person has not worked at all. They accepted that could result in a windfall, but made the point that neither the working time regulations or indeed the original working time directive precludes member states from being more generous than the Working Time Directive might have originally set out. And that's what's happened here. Through the passage of time and the case law as it has gone through, based on the interpretation of the Working Time regulations, it appears that our UK government has given effectively enhanced rights over perhaps what the Working Time Directive ever envisaged. But the law doesn't say that somebody can have, that there's a problem with giving enhanced rights, and that's where the position that we're now in. So the amount of annual leave to which a part-year worker is entitled, if they are on a permanent contract, does not then have to be prorated. And that's what has caused the significant concerns. And Abigail is now going to take you through some of those implications then about who's affected by this change and the implications that means for you as employers.
Thank you. Yes, so what we would say is that Harpur Trust does leave a lot of threads loose that are likely to have to be dealt with in subsequent case law, unfortunately. But what we have put together is to try and explain, because certainly a lot of the questions were looking at who will be affected. We've tried to explain as succinctly as we can who is likely to be affected by this decision and who won't. So permanent full-time workers, they're people that are on salaries, that are paid continuously, ongoing contracts, they should not be affected. And those individuals who are not paid overtime, that have to work as many hours as deemed necessary for the proper performance of their roles, for example, it will be straightforward. For each week of pay, or just look, for each week of holiday, they'll just get paid the equivalent of 1 week of pay. So their salary divided by 52. Now, permanent part-time employees or workers should also not be affected by this decision. If they work part-time throughout the year and therefore work 52 weeks of the year less 5.6 weeks holiday, or however much holiday they are entitled to under the contract, if more, then they won't be affected. And somebody who works 3 days a week, they would still only be entitled to 3 days a week per week of holiday, because essentially that's the number of days off work they need to be given in order to have a week's leave. So the pro-rating you do for permanent ongoing part-time employees who work throughout the year will not change. Shift workers, now they could be affected by the decision. It will all depend upon the shift pattern. And what you need to see is there are whole weeks that they are not required to work, because in the case of Harpur, she wasn't required to work for 8 something weeks of each of the long holidays. So she was not required to work in the non-teaching time, the holidays. So there were lots of weeks where she did not work and was not paid. Now, shift workers, you would need to look at individual shift patterns to determine whether there are more than 7 days in a row where they are not working, because a week for this purpose is 7 days. Term time workers, they will be affected. They're the people that are likely to fall within the Harpur Trust scenario, where they are on permanent contracts for a whole year and the hours of pay varies. Because what is pertinent to Harpur Trust was that she was a full year worker, but only working part of the year, and her hours varied, as did her pay for the hours that she worked. Moving on to casual bank workers. Casual bank workers should not be affected where they're only engaged for specific assignments. And what you are looking for in the case of casual bank workers and zero-hour workers is whether it can be said there is an umbrella contract. An umbrella contract is a contract that spans all the year. It's an ongoing contract which binds the worker and the employer under some duty, a mutuality of obligation during the periods that they're not working. Now, if there is an umbrella contract, they could well be part-year workers if they're only engaged to work part of the year. But if the contract is quite clear, the zero-hour contract, the bank workers contract, is that you'll be given an assignment But in between assignments, you'll have no obligation at all to be offered another assignment with us. And equally, you don't need to accept an assignment we offer to you. If you want to go into work for John Lewis, work for John Lewis. You don't need to come back to work for us. Then that arrangement should not have the impact of Harpur Trust, because there's no ongoing contract. So for casual bank workers, 0-hour contracts, it's really important to look at your contract and to ensure that there is no mutuality of obligation and relationship between each assignment. Seasonal workers should again not be caught, because they will only ever work part of the year, and in most cases, therefore, you wouldn't expect the contract between the employer and the seasonal worker to continue in non-season times. It would make sense for their contract to say you're engaged for 3 to 4 months only. Thereafter, do as you please. If you want work next season, let us know, and if we've got any to offer you, we might, but there's no obligation on you to accept it and no obligation on us to offer it. So again, after this, you really should be looking at those contracts of all those workers to ensure that there's no umbrella contract created. So what now? Well, again, if we just recap on the important thing of Harpur Trust, it was the issue about having them employed for the full year, but only working part of that year on variable hours. So it's important to do an audit to check all of your contracts, that those people that may be part-year workers, that includes your casual contracts, 0-hour contracts, and if you have seasonal workers, those as well, to ensure, to check whether there could be said to be an umbrella contract, so that they're actually employed throughout the year, albeit that they're only required to work part of the year. Now, if you have any of those, then I would suggest you look at how much holiday pay they would have been entitled to and look at the shortfall. But the important thing is that if they have an entitlement to an unlawful deduction of wages claim, if there has been any shortfall, then look at any gaps of more than 3 months in the series, because at the moment, until we have any clarity on that position, the EAT's decision in Bear Fulton should hold firm for now. But we certainly know that the backstop is good, because that's a legislative change that was brought in. So the shortfall will only give rise to a liability going back 2 years. Workers will forfeit holiday also not taken in the current year, unless they can rely upon the King versus Sash Windows and Smith versus Pimlico decision, whereby they could argue that because they hadn't known that they had the right to paid leave, they were not told they had the right to paid leave, then they haven't forfeited their entitlement, and they would be entitled to all of their outstanding holiday upon termination. So how can we get around the windfall? Well, as I said, to recap, it's the main issue is being on a permanent contract where they're only required to work part of the year and having variable hours. So the first thing you could consider is to engage them on 0-hour contracts for short-term engagements where there is no umbrella contract between engagements. So you're very clear that they're only entitled and they're only being engaged for a specific period of time, after which the relationship will terminate. There'll be no obligations between either party during any break between engagements. So, for example, visiting music teacher such as Miss Harpur, she could have been engaged on a contract for just one term, 1 to 10 weeks, with specific fixed hours for the lessons that you could offer to her. And at the end of that contract, her engagement would be terminated, and she could then be paid in lieu of all of the holiday that had accrued during the engagement. But there should be no contract in the holidays. Now, we know that her continuity of employment might continue if she's offered another contract in the following term, because there's existing case law, particularly in the education sector, that can bridge the gap where there's a temporary cessation of employment, which there will be in school holidays. But it shouldn't stop there actually being a gap an actual 2 contracts, and therefore the ability to pay in lieu at the end of the contract for all the holidays being taken, or to build in some time during the first contract during which they can take their holiday. However, this arrangement will far better suit businesses that can have a bank of workers and employees who they can call upon, so they can genuinely show that they don't have to offer work to a specific person, and they don't. At the beginning of each term, for example, they have a selection of music teachers they can offer the work to, and they do so as and when they feel they're the right fit, and therefore they can show that there's some terms when they haven't offered any work and that work has been offered to another individual. That would help to stop there being any argument that there's been an umbrella contract. And the next option we have, the downside of that is that there is less control because you're keeping them at arm's length. And it is likely to create more of an administrative headache, particularly in the education sector where they might need repeated DBS checks. But there is also the concern of building up an umbrella contract if you don't have too many workers you can call upon. So your practice is that you do use the same people term in, term out, and therefore the case law and the legislation is likely to bridge that gap, so there'll be continuity of employment and there might be deemed to be an umbrella contract. So it won't fit every situation. The second option is trying to get around this issue that Ms. Brazel in the Harpur Trust case had variable hours and she was only paid for the hours she worked at the end of each month. So instead you could try and guarantee a number of hours and spread those over a 12-month basis. So you agree at the beginning of the contract how many hours that you can offer to them, and that will be the set number of hours. If you do have to offer overtime, then that would be paid on top if there are any other hours of work that you could offer as well. And the benefit there is that you should then be able to, you might argue that a week's pay for holiday is a week's pay. And alternatively, if you do have more overtime than you might have budgeted for because there's more people that want the lessons or the work, there's more work that they can be given, and they do so in the form of overtime, which doesn't need to be paid more than their hourly rate. That would mean that when you calculate holiday, you do have to look at averaging out their holiday. But the benefit is still that because of the case law we looked at the beginning, when you look at calculating the holiday pay with overtime, it will only apply to the first 4 weeks of leave that derives from the Working Time Directive. The 1.6 additional weeks leave can be paid without overtime having to be considered, because the overtime and the issues relating to overtime only relate to the Working Time Directive derived holidays. So if we look at this box, it means that because of that, because you don't have to pay as much overtime in the holiday as you would, but you just focus 1.6 weeks holiday on the actual hours you've agreed, there should be a much lower level of overall holiday pay paid than under the Harpur Trust Windfall. However, the downside to that is we accept it's a complete administrative headache for employers to work out 2 lots of holiday pay, that relates to the 4 weeks statutory leave and that which relates to the 1.6 additional statutory leave. And also there has been case law in respect of redundancy pay, looking at the week's pay in the Employment Rights Act, which determines that you should always look at the pay that is apportionable and payable for the week that they work. However, we believe that that is absolutely going down rabbit holes, because if you look at normal teachers, it's acknowledged that they don't work during for the holiday times, but you still only pay them holiday based on 5.6 based on their normal remuneration. So we would hope that if you average out pay over 12 months and based on guaranteed hours that you can offer them, then that should be their normal remuneration for holiday pay purposes. But that is another loose end, unfortunately, that is probably going to be determined by future case law. so the position is far from certain. So we're now going to look at some questions that were posed when people registered. So we've chosen ones that cover quite a few of the questions we received that were on similar forms. So the first question: what are the commercial options of managing holiday pay for casual staff? What is the risk of continuing to pay 12.07% of salary? Casuals love it. So the percentage method is still good for those people that are not part-year workers. So for those genuine casual workers, zero-hour workers that are just working as and when with no umbrella contract, i.e. no relationship in between assignments, then that is still a good way of calculating the holiday. However, following King versus Sash Windows and Smith versus Pimlico, the steer is clearly that you ought to be paying holiday when they take holiday. So the safest method is to use that as a tool to calculate holiday, but to then pay it to them during a period of paid leave, or at the end of the contract, you can pay them in lieu. So second question, do we backdate the calculation on current pay or pay rate at the time that it applied? And what about the national living wage? Well, it should be the pay that applied at the time of the holiday. So it's the date that applied at the time of the entitlement. There's no requirement to substitute it to the national living wage if that was introduced subsequently. However, it is important that all pay is compliant with the national minimum wage. 3, so does this affect regular part-time workers? How do we calculate holidays for those on zero-hour contracts? Part-time workers should not be affected. So you would calculate their holiday based on the part-time hours they do. So again, if they work 4 days a week, they would only need 4 days pay, so to 4 days leave to take a week's holiday. So they'll be entitled to 4 days times 5.6. In respect of zero-hour contracts, if they're part-time, then that's why the 12.07% calculation, the percentage method, is so popular, because it allows you to really assess and calculate holiday based on an hourly basis. But of course, if you have an umbrella contract, and that's why it's so important to audit your contracts, then you might be in the Harpur Trust situation where you have to actually give them 5.6 weeks based on average of 52 weeks. Does this impact seasonal workers? We've looked at that before, and no, it shouldn't, but it will depend upon your contract. So again, brush them off, read them through, and just check that there is no umbrella obligation, that they could be said to be permanent employees working part-year. But provided they're only working for a period of the year and then the engagement terminates with no ongoing mutuality of obligation and relationship between the parties, it should be possible to just pay them for the holiday that's accrued during their engagement. 5, how far back can term time workers claim back pay? And that should be 2 years, but if there is an interval within that 2 years of a series of deductions of over 3 months, at the moment, that should preclude them being able to use the whole of the series. It should break the chain in a series of deductions, but we have to give that health warning because of Smith versus Pimlico and the obiter comments of the Court of Appeal. Question 6 should arrive. So how would you advise we prepare a deal to deal with issues of potential claims for back pay? Well, the first thing is to do an audit, to work out how many part-year employees you have, then to calculate their holiday based on the calendar method for the preceding 2 years and work out the shortfall. And then how you choose to then pay it, if you pay it at all, is a completely commercial decision for you. You could either pay it in full, or you could assess whether there is any 3-month breaks in a series of deductions and take the view that you'll only pay them the back pay up to the first break in that chain due to the interval. Or you could just wait for employers to bring claims, but pay future holiday pay based on the correct calendar method. And if you pay them through through the holiday calendar method, therefore the correct method, that should then, from the date you pay them from the holiday they've taken, that should break the series of deductions, making it more difficult for them to bring a claim in respect of holiday pay that they took and were paid for beyond 3 months from the date that you paid them in line with the calendar method. And then question 7. So if a part-time worker has contracted hours per week, does the judgment affect them as well as casual employees? And as we've said, that they should not be caught if they're on fixed hours working across the year. The Harpur Trust judgment, to summarise, only primarily covers those working a full calendar year, but who only work part of it and whose pay varies with the hours worked. Now, as I said, there's lots of loose threads. That last point, whose pay only varies with the hours worked, is something that might lead to more case law. But at the moment, they're the 3 key factors that gave rise to the Harpur Trust decision. So there's a summary of the questions that we had in advance. Do you have a few minutes?
Yeah, I'm just looking at some of the other questions, Abigail, that we've been asked. A number of them we hopefully have actually answered as the session has gone through. But one of the themes of some of the questions that are being asked is this ability to try to identify whether or not a casual worker is engaged under an umbrella contract or not. And I think actually there's been various questions about whether somebody remaining on the payroll during any gaps in assignments would mean that there is an umbrella contract in place or not. And I think it's very difficult to give a very clear answer that relates to every single situation that you might have in your various organisations on this, because the courts look at it in such a fact-specific manner, really. But generally, it's all about whether there's an ongoing obligation. So as Abigail's been talking about, this mutual obligation between the worker and the employer in any of those gaps. So whether there's a requirement to keep in touch with each other or to sort of be available to work in any way. Being on the payroll, whilst of itself I don't think would be absolutely indicative of an ongoing relationship, it would point in that direction a little bit, I would say. And so in an ideal world, somebody wouldn't remain on the payroll in between times. Abigail, do you agree with that?
I would agree. I mean, the issues I think we're going to see is areas where they use bank workers a lot. So the NHS has been one, for example. And there you really do need to look at the frequency in which you're engaging people and whether you're using them in such a way that they've actually almost become permanent employees. But if you're not using them frequently and there are gaps, the contract needs to be explicitly clear that they can, work elsewhere and that you may not give them work. And if you can show as a matter of practice you don't always give them work because you've got a whole other stream of people that you give work to, then hopefully that will prevent that individual from being deemed to have an umbrella contract. But it is very important you look at the contract wording and then also apply how it's been working in practice. But as Sonya said, unfortunately, it is so fact specific that, in an organisation that's using a large number of casual workers, you might find that actually it can change from casual worker to casual worker depending on how frequent or the way you've been engaging with certain casuals, where there's a specific pattern, i.e. someone that always works every Saturday or twice a month, but the same 2 days every month.
Yeah. And another question on a similar line about whether or not with a 0 hours contract, the actual contracting arrangements itself, whether you can have an initial contract that stipulates that people will only be allowed to work or required to work rather from time to time, rather than having to issue a new contract every single time. I think, again, much depends then on the words of that contract and exactly how clear it is about whether or not there is genuinely an entire break in any obligation on either part in any gaps. And I think that's really a matter for looking at the wording of the contract and being extremely clear. Again, in an ideal world, I suppose you would have individual contracts every single assignment, but I appreciate that is administratively very burdensome. So none of these things have hugely straightforward answers, I'm afraid, but I think that it really is a case of looking on an individual basis at the contractual arrangements that you have and making sure that they genuinely reflect what is actually happening on the ground for a particular worker. Because of course, as we know, very often a contract will say one thing, but the reality is something different on the ground, and that an umbrella contract might then be able to be determined if it's actually how the person is working day to day.
Yes, yeah, I agree. So that brings us to the end of our session today. You will receive a feedback form from us. I really hope that you'll take the time to complete that. We'd love to have your feedback. If you would like to join us at our annual updates, we'd love to see you in person at those, for those of you that can come along. And we'll be looking at this case in a little less detail, as well as lots of others as well. So we look forward to seeing as many of you there as we can. But from Sonya and I, thank you very much.
Thank you.